Hello, I am Professor Debt Remedy, and welcome to State Administration Services tutorial on Deeds of Company Arrangement. A deed of company arrangement is a formal agreement between a financially distressed company and its creditors, designed to provide flexibility and a chance for the company to continue operating, return better outcomes for creditors, and remedy debt issues outside the direct path of liquidation. In Australia, the administration and oversight of these arrangements fall under the purview of state and national regulatory bodies, including registered insolvency practitioners and administrators. This tutorial provides a thorough explanation of how a deed of company arrangement works, step by step, highlighting the role of state administration services, the processes involved and the remedies available for company debt. Understanding company administration and insolvency. Before delving into the mechanics of a deed of company arrangement, it is essential to understand the context in which such arrangements are made. When a company becomes insolvent, that is, when it cannot pay its debtors and when they fall due, it may enter into a voluntary administration process. Voluntary administration is a statutory procedure under the Corporations Act 2001, CTH, designed to resolve a company's future quickly and fairly. The administrator, an independent insolvency specialist, is appointed to take control of the company, investigate its financial affairs, and advise creditors on the best course of action. This may ultimately result in one of three outcomes: returning the company to its directors, rare; entering into a deed of company arrangement; placing the company into liquidation. What is a deed of company arrangement? A deed of company arrangement is a binding agreement between a company and its creditors, facilitated by an administrator. Its purpose is to maximize the chances of the company continuing to exist, or, if that is not possible, to provide a better return to creditors than an immediate winding up. The terms of a deed of company arrangement are extremely flexible, tailored to the unique circumstances of the company and its stakeholders. What are the key features of a deed of company arrangement? Flexibility. The terms and structure can vary widely, allowing parties to devise creative solutions to debt problems. Binding nature. Once approved, the deed of company arrangement binds all unsecured creditors and, in some cases, secured creditors. Administrator's role. The administrator oversees the execution of the deed and ensures all parties comply with its terms. Legal standing. A deed of company arrangement is a formal instrument under the Corporations Act and is enforceable by law. The process, from administration to deed of company arrangement. 1. Appointment of an administrator. The process begins when a company's board of directors, a liquidator, or a secured creditor with a charge over most of the company's property appoints a voluntary administrator. This typically happens when insolvency is imminent or has already occurred. 2. Investigation and reporting. Upon appointment, the administrator assumes control of the company. Their primary duty is to investigate the company's affairs, assets, and liabilities. They engage with stakeholders, assess the company's financial position, and consider whether there is a reasonable prospect of its survival or a better outcome through some arrangement, such as a deed of company arrangement. 3. Proposals for a deed of company arrangement. During the administration, various parties, including directors, shareholders, or even creditors, may propose a deed of company arrangement. These proposals outline how the company's debts will be dealt with, including repayment terms, restructuring plans, or other arrangements designed to satisfy creditors' claims. 4. Meeting of creditors. Within a prescribed period, the administrator must convene a meeting of creditors. At this meeting, creditors are presented with the administrator's report, which includes recommendations regarding the proposed deed of company arrangement or liquidation. Creditors may discuss, amend, and ultimately vote on the proposals. For a 4. Meeting of creditors. Within a prescribed period, the administrator must convene a meeting of creditors. At this meeting, creditors are presented with the administrator's report, which includes recommendations regarding the proposed deed of company arrangement or liquidation. Creditors may discuss, amend, and ultimately vote on the proposals. For a deed of company arrangement to proceed, it must be approved by a majority in number and value of the creditors present and voting. 5. Execution of the deed of company arrangement. Once approved by creditors, the deed of company arrangement must be executed within 15 business days. Unless the court grants an extension, the company administrator, who is now called the deed administrator, and any relevant parties sign the deed, making it legally binding. 6. Supervision and operation. The deed administrator manages the company in accordance with the deed of company arrangement's terms. This may involve continuing trading, realizing assets, restructuring debts, or other specified actions. The administrator is responsible for distributing funds to creditors as outlined in the arrangement. 7. Completion or termination of the deed of company arrangement. A deed of company arrangement ends when its terms have been fulfilled, or if it is terminated by creditors, the court, or due to a breach of conditions. If the deed of company arrangement fails, the company may be placed into liquidation. State administration services may play a crucial role in overseeing the voluntary administration and DOCA processes. These services typically involve liaising with registered insolvency practitioners who are licensed to act as administrators and deed administrators. The process is guided by the National Corporations Act but is supported by local courts and regulatory bodies. Into liquidation. Key responsibilities of the deed administrator are ensuring compliance with statutory requirements, providing transparent communication between company, creditors, and regulators, assisting with the preparation, execution, and supervision of deed of company administration, reporting on the progress and outcome of the administration process. The principal aim of a deed of company administration is to provide a remedy to company debt in a way that maximizes returns to creditors while potentially allowing the company to continue operating. The terms of a deed of company administration may include payment of a lump sum to creditors, payment of debts by installments over time, sale or transfer of company assets, restructuring of company operations, moratorium on creditor claims during the period of the deed, release of certain debts or claims against the company. A deed of company administration can provide an effective alternative to liquidation, in which assets are sold off, and creditors may receive a smaller dividend. By contrast, a thoughtfully structured deed of company administration may result in creditors receiving a higher or quicker return. Advantages of a deed of company administration are potential continuation of the business, preserving jobs and value, greater flexibility in resolving debts, higher or earlier returns to creditors compared to liquidation, binding all unsecured creditors to the agreement, stopping legal actions against the company while the deed of company administration is in place. Limitations and considerations. A deed of company administration may not bind all secured creditors unless they consent. Execution depends on the company's ability to meet the deed of company administration terms. If the deed of company administration fails, the company may ultimately be wound up. Directors' personal guarantees are not released unless specifically provided for. A case example of a deed of company arrangement. Suppose an engineering company based in Sydney encounters financial distress and enters voluntary administration. The directors work with the administrator to propose a deed of company arrangement which involves selling a non-core business asset and paying creditors 70 cents in the dollar over 18 months. Creditors, after reviewing the administrator's report and considering the likely lower returns from liquidation, vote to accept the deed of company arrangement. The company is able to continue trading, jobs are preserved, and creditors receive a better return, thus demonstrating the practical benefits of the deed of company arrangement process. Conclusion. A deed of company arrangement is a powerful tool within Australia's corporate insolvency regime, providing distressed companies with an opportunity for survival and creditors with a chance for a better outcome than liquidation. State administration services may play a pivotal role in ensuring these arrangements are executed for the benefit of both debtor and creditor. While not suitable for every situation, a well-structured deed of company arrangement can be a lifeline for companies facing insurmountable debt, a vehicle for innovation in debt remedy, and a cornerstone of responsible corporate governance.